We're going to go ahead and begin the meeting proper now, or the presentation proper now. I'd like to introduce Acting Chief Justice Andrew Mead and Justice Robert Mullen. They're going to be discussing the state of the courts and hopefully discuss some of the steps that are being taken to return to a bit more what we remember as being normal. Acting Chief Mead.
Thanks, Chris, and thank you to the Maine Trial Lawyers Association for making this opportunity and platform available to us to get the word out on what's going on within the judicial branch. There is a lot going on, and in the limited time allotted here, I'll try and give an overview of where we are now, particularly our planning for the future, which will be without COVID. Thank you. I'm going to skip largely over the jury issues. I'm going to defer to Chief Justice Mullen on that. He'll give you a report on the on-the-ground goings-on with the trial courts and particularly the jury issues, which I know you're interested in. As was mentioned at the outset, we do welcome questions. We'll do the best to answer your questions. If we can't give you a full answer, we will try and get the information and report it back to the MTLA leadership for dissemination to you. So if you have a question, send it in via Zoom, and Chris is going to collect and organize the questions and pose them to us during the Q&A session at the end. And Justice Mullen and I will do our best to try and get to that no later than perhaps 8:40 or so. So we'll do the best to compress a lot of information into a short period of time. So here we are. It's the 1-year anniversary. A lot of people are saying it's no cause for celebration, but I think we can give ourselves a little bit of a pat on the back to say we're still here. We've done the best we can during this really challenging year. In order to understand where we are now, we do need to take a quick look back at some particular points during this preceding year. I'm not going to go into detail. If you want a fuller historical perspective, you can access my State of the Judiciary address, which is done by video recording this year. It was released by the legislature earlier this week, and we can give you a link. I think Steve has a link. He may pop up via the chat box or whatever. And we will also make the text version available to you. It runs about 30 minutes. If you'd rather read the text, we can certainly do that. But the historical perspective is there. I'd like to take you back just briefly to September and October of 2020. We were pretty optimistic during that time. We were headed into phase 5 of the phased management plan. Phase 5 opened up all case types for scheduling. It also opened up the prospect of jury trials. And as you know, I hope you know, we conducted jury trials successfully. We can do them during the pandemic. They took place in Bangor and in Augusta. Both of those locales were favorable because they had large multi-purpose rooms and multiple courtrooms available at the time. So things were looking up for us back in September. But then as late October rolled along and November occurred, as you know, the trajectory took a real turn for the worse. The numbers started skyrocketing. We took a look at that and we faced the unfortunate reality that our resources were being maxed out, with in-person scheduling being limited by capacity controls and limited judicial resources, including incongruously marshals. The availability of judicial marshals was a significant limiting factor. Our dockets were filled fully with priority cases, with no room to fit in other case types. We were using video remote, Zoom, more and more, but still could not take up the slack. So by November, we issued an addendum to our phased management plan. I issued a statement. It really was a reality check. Things were on hold. We couldn't move forward in the way that we hoped to move forward. Through January, the virus rates and infection rates really continued to soar during that period. We had some brushes with infected people in the courthouses, but we somehow avoided being community transmission sites. In-house, we created our own virus monitoring resources with color-coded indicators by individual court locations. And back in those days, most locations were in the red, or at least headed to the red. It was deeply concerning. We created a court closing scenario, a plan based upon local decisions. We involved our local judges in conjunction with our trial court chiefs so we could close individual courthouses as opposed to the statewide process we had been using in the meantime. All the while, we still continued to try and innovate and expedite. Lots of things took place that moved us forward. For instance, Zoom, video remote. In August of 2020, we managed 200 something Zoom sessions. That includes both meetings and judicial processes, a little over 200. As of February 2021, we had over 1,600 Zoom sessions taking place. But still, the challenges were enormous. It was grim. The backlogs continued. By February 2021, we had approximately 27,000 backlogged criminal cases. This is up by 10,000 from the previous year. So we were very, very concerned. But in the recent past, the very recent past, I think we have cause for optimism. We on the judicial branch side are very optimistic. We have started over the last couple of weeks looking and planning for our post-COVID future. We're still in the pandemic, we know that. We're still looking for new approaches to handle the pandemic. For instance, the small claims remote mediation pilot program is underway. But we are starting the process of looking forward. Within the JB, we are looking at organizing working groups, and these groups will look at our existing practices, deciding which COVID practices should continue after the fact, looking at our previous practices, should we continue those, should we go back to those, and I think most importantly, looking for new practices, new procedures so we can attack the backlogs aggressively. We're putting a charter together right now for a clerks working group. This is in-house JB. The clerks see everything at the ground level, and I think they will have some great ideas about how to move on. Maybe we'll have a judges group, but I think more importantly, we want to put together working groups that will involve stakeholders, folks out there who may have some really novel ideas that we wouldn't have thought of. At a recent Justice Action Group meeting, Chris, who was attended on behalf of the MTLA, indicated very clearly that MTLA would be very interested in being involved with those groups, and we welcome that. So I'm hoping within the next weeks, in the very near future, we will start creating these looking forward groups. And then when something like normal happens, we'll be prepared. It will be all hands on deck. We're going to fully leverage active retired judges. We're trying to get more marshals authorized, funded, but basically it's full steam ahead. When we hit that, when will it be? Hard to say. There's planning underway for jury matters as early as April and May. I'm going to hand off in just a moment to Chief Justice Mullen to talk about what's happening in the trial courts, but that's where we are. We see the end in sight. I would be just delighted if the COVID numbers were down and late June, early July, we are back to business as usual. All case types, jury trials storming along and moving ahead to address these backlogs. So this is an overview. There's much more going on. And if you have any questions, I'd be happy to address more specific points. But at this point, I will hand off to Justice Mullen, who will give you the update on what is happening on the ground with the trial courts. Chief?
Well, thanks, Chief. Good morning, Attorneys Lewis, Mann, and Biggis. I want to thank you and your membership for the opportunity to address you today. I think I was told that maybe 150 people have registered, and that's a great turnout. I have to say I miss a bit the Jeopardy format that Steve confirmed for me that you had once during the judges part of the program. But I hasten to add, I only missed it a bit because whenever I play Jeopardy with my kids, I usually end up being like that contestant on the real Jeopardy game show that ends regular Jeopardy in the minus money column. which always prompted Alex to inform the contestants, sorry, but by our rules, you can't play Final Jeopardy. And I always felt bad for that person. And now I've relived that, although only with my family. I realize we have a limited amount of time today, so I'm going to want to make sure that we welcome the chiefs and the trial chiefs, welcome any and all ideas as to how to tackle the challenging task ahead, which namely is to reduce and eliminate the backlog of cases, both criminal and civil, that clog our dockets right now after being forced for a year of basically doing no trials at all. Civil cases haven't been forgotten. However, at the same time, it's tough to argue that the court should concern itself with matters when the primary focus is, let's be honest, money damages, when there are a substantial amount of pending criminal cases where person's liberty is at stake, either because they're in jail or they might end up in jail, depending upon the verdict. The numbers for the backlogs are kind of almost already alluded to by the chief are daunting. Amy, if you can put that slide up, number 1. You can see that a year ago, and this is as of March 12th, so it's about as current as we can get. A year ago in criminal, we had 17,000 odd cases. A year later, we have almost 10,000 more, just a hair under 27,000. In civil cases, we had 2,059 cases. Now we have 2,233 cases. That's obviously an increase, and I think it's fair to say that COVID definitely curtailed the number of filings and so forth. But so we still have a big backlog in both. Some counties are in relatively good shape, or maybe more accurately, I should say, are in better shape than others. And if you can put slide 2 up, these are county by county, the number of civil cases that the clerks told us, if we were putting together a trial list tomorrow, these are the cases that are ready to go. The top 5 counties, no big surprise, are Cumberland with 64 cases that we could put on a trial list tomorrow. Androscoggin is next. York is not far behind Androscoggin, and then Penobscot. And then we have some counties that are just ill-equipped to go forward with jury trials, period, whether they're criminal or civil in nature, just due to space constraints, such as Franklin County. I'm hoping that we are going to get to jury trials, period, in Franklin County, maybe at the end of the summer. But the big problem is, as long as we have 6-foot social distancing, it's just virtually impossible to fit enough people in the courtroom for jury service. And we'll get to that in a second about some things we might be able to do differently. We recognize that civil litigants have rights as well, rights that are respected by the judicial branch. And believe me, we're painfully aware that we can't continue to put everything on hold indefinitely. One way of attempting to dig out from the civil backlog is being discussed presently by a group of attorneys, some of whom are on this call today. Your president, Attorney Lewis. The group is chaired up by Associate Supreme Court Justice Mark Horton. His group doesn't have a formal name, I don't believe, but he told me yesterday anyway, he refers to it as the Judge Attorney Civil Jury Trial Working Group. I think you've met already 3 or 4 times. Your next meeting is at the end of the month, I think on March 31st. There are multiple attorneys on this group, and Justice Horton tried to split it up for geographical parity, plaintiff's bar, defense bar, etc. Attorney Lewis is the MTLA designee, and I think the Bar Association designee is Attorney Jennifer Krekel. And according to Judge Horton, they're discussing is two possible avenues of relief from chipping away at the backlog of civil cases. And one is something that we did pre-COVID in certain counties, which would be adding civil jury trials as backup cases to criminal cases on a docket call. This would require an amendment to the PMO, which presently makes it pretty difficult, if not impossible, to have civil jury trials. We can talk about that in a minute. These cases would be strictly backup in nature, and there would be no displacement of criminal cases. There is some sentiment that perhaps the rule should be expanded a bit so that there's no displacement of criminal in custody cases, people who are in custody and waiting a trial, but perhaps intermingling a few civil cases among the criminal trial list, especially if it's predominantly a misdemeanor docket, where the defendant's not in custody, and perhaps the case, if it's an OUI case, it's 4 or 5 months old versus a civil case that has been pending for years. Maybe there should be some dispensation for that type of case, but that's a discussion for another day. Attorneys Drury and Lewis, I understand, have already come up with a list of cases that they have pending that are ready to go, and that they would be perfectly fine with being placed on a backup status. So that might be a good idea to think about at some point, or be prepared to provide to the court some civil cases you have, which you think would be amenable and a good case to put on a backup status. The other concept involves virtual jury selection, jury trial selection. And as I understand it, questionnaires would be sent out to jurors electronically with paper copies to those who don't have access to the internet. There'd be a program at the courthouse, an electronic program at the courthouse. You'd make out your questionnaire, you'd send it back. There'd be a program at the courthouse that could scan the return questionnaires and at least rule out certain jurors depending upon the answers that they gave to certain questions. That would dispense with attorneys and clerks and judges going over the questionnaires, which is time consuming and can be tedious. The jurors who pass the questionnaire test would be subject to virtual voir dire by counsel and the court. There'd be breakout rooms for exercising your challenges for cause and peremptory challenges. If you needed individual voir dire, there'd be a breakout room for that, etc. This will take some training for the attorneys and clerks and judges, but we think it's doable. The group thinks it's doable, and I agree with them. The book hasn't been closed completely on virtual jury trials either, but I think that's a much bigger project with significant challenges. There's not a lot of support for that, I don't think, even among the bar at this point. So that's a topic for another day as well. As I understand it, Judge Horton's group is putting the finishing touches on these proposals with a hope to have them finalized by either next month or May, and then present the proposals to the trial chiefs in the law court. The virtual jury selection would result in serious time savings in terms of not having to go over all the questionnaires manually, as I've said. There'd be a saving in time for jurors and savings in mileage costs. We are always worried about pre-COVID about getting people to show up for jury duty. Maybe this would be a lot better, and I would think would be more popular, and thus it would be more efficient. I also think it would allow for better voir dire, perhaps, because attorneys would be able to really eyeball prospective jurors, albeit they'd be on a TV screen or a computer screen, but you'd be a lot closer than looking across the courtroom and trying to see if what their attitude is, and especially looking across the courtroom where a person presumably would have a mask on, at least least for a few more months. Before I finish, I want to make sure that people understand what the law court and the judges refer to when we're talking about case priority types. They're mentioned on the JB's priority scheduling policy, page 11 of the PMO, which is dated 3/15/21 of this month. They were created almost 19 years ago, the case priority types, when probably a good number of you might have been still in law school or perhaps even in college or high school, not unlike myself. I see a couple people paying attention. Okay. I was fortunately or unfortunately, I was around when these were created as well. Julie, can you Amy, can you put up slide 3? Okay, hopefully you can read that, but basically what it says is it's a statement of judicial branch priorities in light of current fiscal constraints. So back in 2002, it seems like it's a yearly event, but we had some fiscal constraints, and so the law court put together what they termed the top 3 priority case types of the judicial branch for the purposes of planning, developing the case management protocols, and resource allocation. That means marshals, clerks, and judges. And the first priority was urgent matters, such as protection from abuse matters, preliminary protection orders, 48-hour hearings for people who are incarcerated who couldn't make bail, any emergency order regarding parental rights and responsibilities, TROs, and then permanent protection orders. So that was the first priority case type that we needed to address. The second was family matters. That's on page 2. Oh, there we go. Page 2, talking about child protection, parental rights and responsibilities, divorces, juvenile cases, any other case where a child's welfare is at stake. And then the third priority was criminal matters. And the first subset under criminal was people who are incarcerated, cases involving victim issues, sex cases, establishing a bail, things like that. And then other matters, and civil jury trials are not even mentioned, but they fall under other matters. And so when judges are talking to you about, we've got to schedule according to the priority scheduling that's been in effect for 19 years, that's what they're referring to. This is the document. I've probably gone too long. I apologize. I just want to close by saying we really are in this together. We're all in this together. I think the judges all feel that way. Or as the boss saying, we're all riders on this train. We will get through this. I think we are on the second side here of getting through this, and we'll do it together. Thank you very much for the opportunity to speak to you.
Thank you very much, Chief Mullen. Chief Mead, do you have anything further before we open up to some questions?
Oh, but I saw one question I'm looking forward to answering, so I'll just hand off to you.
Well, I can't get in the way of that if you're that enthused about a question, so please feel free.
I am. I think I saw one pop up in the chat. I think it was from Jeff Russell. Don't recall who it was. And the question basically, it was a question and a comment. It said, essentially, what is the future of Zoom proceedings, remote video proceedings? Is the court going to continue them? And I think he mentioned that it's cost saving and time saving practice that is a good thing. So to tee that up, I just want to share a conversation that I had with my colleagues, all 6 current members of the court, and we were talking about the future of video. And as you know, I hope you know, all law court arguments have been by video since the pandemic kicked in. And so we're having the conversation, and it turned obviously to the perception of the bar about it. And almost simultaneously, a couple of colleagues said almost at the same time, they love it, they hate it. They want to keep this, they want to get rid of it. So obviously we have a limited opportunity for input. our sense was that it was working pretty well, that it's actually a good format, at least in the appeal setting. The lawyers can see who they're talking to and who's coming back. It seems to be very organized. But the reason why I appreciate the question is because we need to get some input on that. And I'm going to sort of turn it around and ask the MTLA if you folks would consider perhaps doing a survey of your membership, maybe doing an online survey tool, asking whether they like the virtual proceedings, both in the appellate setting and also the trial setting, because it is a little bit different. It's a different concept, but maybe one of those survey tools where you say, you know, should video be continued? Strongly agree, equivocal, maybe, absolutely not. And if you could tabulate those answers, that would be of enormous value to us, as opposed to our anecdotal reports, which may or may not reflect the majority view. So if your members feel that, yep, the video has a real role in the future, both in the trial and the appellate setting, or no, we want to get back to the old in-person because it's better, that would be very, very helpful to us. So thanks for that question. And that is, as I said, we're looking at everything we're doing right now. Should we continue it? We have, as you know, we have a pile of PMOs out there. The PMOs, the pandemic management orders, are really agile management tools. We can change those on the fly overnight, and we have done so frequently in the recent past. So some of those practices we may want to keep, and some of them we want to drop kick out of here just as soon as we possibly can. Things like submitting filings by email, which is not e-filing, that's something different altogether. But by submitting pleadings by email, that was very well received. We actually rolled it back, and the bar said, no, we like that, so we reinstituted it. And I should mention also, just in passing, I'd rather defer to the questions, but I will mention in passing that e-filing is up and running for limited case types in Bangor and the BCD, the Business Consumer Docket. And I don't think we got this message out clearly enough when we started it up. This is a pilot project. This is a shakedown cruise. What we're trying to do is find out what needs changing, what needs adjusting. And we thought there would be some. It turns out there are a fair number of things that need adjusting. And so we welcome your input. There is actually a email address and a telephone number for feedback on how that is going. And we're not going to roll it out to other locations until everything's settled down. We're looking at the hardware, looking at the software, looking at the rules, and we're going to be tweaking all of those, I'm sure, before they're rolled out to other locations. But if you are involved with the e-filing program in Bangor, the BCD, we welcome your input very much so. So, sorry, those are two things I wanted to get out of there before we swung back to the questions. I guess I'll hand back to you, Chris, and let us know if there's other points that we need to address.
Thank you. And just to build upon that previous question, Your Honor, would the court be, well, is the court interested in hearing input from our membership on the retention of the ability to do Zoom depositions? I know personally that would mean a difference in my practice. I would be able to take cases in Presque Isle that I otherwise wouldn't be able to. And I'm sure I know of several insurance defense attorneys probably that would help them as well. Would the court like to have that included in our survey? Very much so, because we, on the court side, the conduct of the depositions, the deposition practice is not something we see on a day-to-day basis. So we can only get a perspective from what you, the practitioners, tell us. And when the pandemic hit, depositions, as you recall, is kind of wild and woolly about who can do what, when, and what's the presumption. So the PMO, I guess, has addressed it to some degree. We haven't heard a lot about it in the meantime, but it was a definite change in the practice. And we would very, very much like to hear from the bar whether those changes should be continued or modified or discarded. As I say, we don't have an independent perspective there. So absolutely, positively. I'm hoping that when we put together these stakeholder groups, we'll get a real, it'd be great if the bar could come together and say, okay, lessons learned, this is what we would like to do going forward. So absolutely, positively. Great. And we'll include ADRs as well. So I think we've, folks have, I think you're probably going to hear some cases are really benefit from remote practice. In some cases, really need to be in person, but having the option might be great, and we'll certainly include that on our survey. Just going to some of the questions for either of the chiefs. Any idea when in-person motions hearing may restart?
I guess I'll hand that one off to Chief Justice Mullen, as he is more boots on the ground as regarding the in-person proceedings and whether that's on the horizon.
Chris, are we talking about in-person civil motions or in-person criminal or both, or there's no, because in-person criminal hearings are taking place at some places. I'm in Skowhegan today. I did 2 motions to suppress in person earlier this week. I've also done motions remotely, completely remotely. Some areas the DA appears, such as up here in Franklin County, for example. I can't remember the last time I saw a DA in the courtroom. And as far as civil motions concerned, I think I think at least myself, feel a little more comfortable doing civil motions remotely because it's a lot of times it's oral argument on a motion for summary judgment or something. I think I leave that up to the particular judge and area involved. They know. The other thing about civil motions, if you're doing it completely remotely, you don't need a marshal. And as the chief has referred to, we are just having a devil of a time with a marshal shortage. We literally cannot open up every courthouse in this state on a daily basis with the marshals that we have. We have to, if we were to open every court, the intent was to open every court. We couldn't because we have to have entry-level screening to ask the COVID questions, and we just don't have enough marshals. And so we're trying to make that pitch to the legislature, and hopefully, everyone's going to them with their hand out, and I get that. And it's a devil of a time to try to figure out, how to parse out resources to whom. But it just seems to me that it's pretty stark when you say we can't open all our courthouses because we don't have enough marshals to provide marshal services to the public and to the judges.
Thank you, Chief. Just going through the questions now to either of the chiefs. When will we be able to access court calendars statewide via the net as we are able to access Portland and Bangor?
I thought something like that was occurring at the present time. I'll have to look into that. Chief Justice Mullen, do you have more information on statewide calendars?
I was going to say I'll hand this over to the chief. No, that's what I thought. I thought court calendars were on.
Okay, that's one of the ones I'll take back to the folks who know, and we'll get back to you with a definitive answer to that. And if they're not available, they should be. So,
and the MTLA will put that information out.
Thank you.
Thank you. Any thought on using Rule 53 for non-jury trial issues?
That has not been teed up specifically as a discussion point, and perhaps it should be. Chief Justice Mullen, anything on your end?
Yeah, we're talking about referees, correct? Yeah. Well, actually, that's interesting because Attorney Brent Baber sent us a letter this week about perhaps getting a stable of experienced trial attorneys who would be willing to take cases on on referencing, and maybe a special rule about appeal rights, and that's certainly something that I think has some merit. I've referred it to Justice Wharton's group. I mean, they're focusing pretty much on civil jury trials. So, but I think it's a great idea, and it might have some legs.
Thank you. Which courthouses are physically capable of having socially distant trials?
I think all of the courthouses to varying degrees can. we early on in the process, we sent out a team to every one of our 34 locations throughout the state to measure and mark and designate socially distanced requirements. Some of the smaller courthouses might only be able to accommodate the maximum number within a small setting. And then the larger ones, of course, would be much more capable. But I think every courthouse would be capable of some degree of social distance trials with capacity controls in place. The capacity controls are tricky also because in many trials, there are multiple parties and spectators who would like to watch, and members of the media who want to have access also. So it can become tricky depending on a particular trial. If we've had a couple of instances with high profile trials where we've had to conduct the trial in one courtroom, but do a remote feed to other courtrooms. We are currently looking at the possibility of creating YouTube channels for courtroom proceedings. And there are obviously reasons why and why not to do that, but we need to socially distance within the courtroom, and we also need to provide access so the capacity controls don't become a de facto bar to the public nature of the proceedings.
Thank you. Just another question that's come in. What can the MTLA do, or either as an organization or a membership, to help the or convince the legislature that we need to get additional marshals on board and just try to get the civil jury trial process restarted?
Thank you for that. As you know, at this time, there's lots of folks who are seeking funding from the legislature with very compelling and absolute meritorious reasons. We tried to get in as part of the governor's budget coming through the door. That was not successful. Our present approach right now is, as you know, there's federal funds coming directed towards unique circumstances created by the COVID crisis. And we have made a request to Commissioner Figueroa that we participate in the distribution of those funds. And I would think if any members of the association wish to support that, I'm sure that would be well received. But I think at the present time, our best opportunities to get in some of those funds that are coming in from the federal support, which are dedicated exclusively to COVID responses. So that's what we're looking at the present.
Thank you. All right, we're getting close to being at the end of our time. Do either Chief Mullen or Chief Mead, do you have any closing remarks you'd like to say to our membership? Chief Mullen, anything?
I guess I'd just like to say that it's been an incredible year, and it continues. For a while, I thought 2021 was just 2020, take two, but I think it's changing. It's been great to work with my colleagues. I think everyone stepped up, and frankly, the bar stepped up. I mean, whether it's civil attorneys who are obviously frustrated, but I haven't had my tires slashed yet, so people have kept that under wraps, and I get it. I mean, everyone's taken a hit. Your practice has taken a hit, but everyone has been pretty good at stepping up and doing new things, trying to keep up with these PMOs and trying to make sure that they comply. And I know it sounds like I'm sucking up, and maybe I am, but I love the Maine bar. I was a member for 17 years before I became a judge, and it's the greatest place to work, at least with the people you work. That as far as I'm concerned, and I just want to thank everyone for their patience, and we'll get there. That's what I want to tell people.
And the same from me. What I would want to say to the bar in general and to MTLA in specific, thank you. We know that for many of you, this situation has caused your practices to grind to almost to a halt, or even perhaps to a halt. And that's just a terrible, terrible situation. And I want you to know that we know and we understand, and it consumes all of our, I say, all of my waking hours and many of my sleeping hours too. And Chief Justice Mullen will confirm this. We meet constantly looking at ways to bust our way out of this. And the bar has been nothing but supportive and understanding, and realize that we're doing the best we can with what we've got. So my message to you is thank you, but brighter days are ahead.
Thank you, Chief Mead. Thank you, Chief Mullen. The MTLA will continue to work closely with the judiciary, try to move these efforts forward. And with that, I'm going to turn this over to Mike Begas.
Great. Thank you, Chris. And thank you, judges. Great to hear from you. A couple more sponsors during this intermission.